Good afternoon, everyone. My first case is His Highness Maharaja Dhiraj Madhavraj Jivaji Rao Scindia versus Union of India. Starting with the background of the case, this took place during the time of the independence. At the time of the independence, over 48% of the area and 28% of the population were made up of princely states. Consequently, at the time of independence, around 565 princely states were present in India. So after the division of India and Pakistan, the princely states were given the choice of either to join India or to merge with Pakistan or to remain independent. Soon after this announcement, VP Menon and Sardar Vallabhbhai Patel started their integration efforts because they knew that if any princely state, if any important princely state talks about joining Pakistan, the dream of independent and sovereign India wouldn't be completed. Going by this dream, Sardar Vallabhbhai Patel put forward the idea that if the princely states join the dominion of the India, the rulers will be guaranteed a privy purse. This privy purse would be basically a revenue from the Indian government to the princely states, and it would be 1/4 of the revenue which the princely states used to receive under the British rule. Also, they would be given the succession according to the law and custom to the gaddi, and they would also be given their personal rights, privileges, dignities, and all the titles. This was the deal which Sardar Vallabhbhai Patel put forward in front of the princely states. Later, all the princely states integrated with the Union of India, abandoning all authority in regard to their territories. Following this, obviously special provisions were enacted in Constitution regarding privy purses and the rights and privileges of erstwhile rulers. Under Article 291, the sum which was guaranteed by the Dominion of India to any ruler that was to be charged and paid out of the Consolidated Fund of India, and the sums so paid were to be exempt from all taxes on income. Following this, provisions were made in various statutes conferring the ruler certain privileges and benefits. By Article 366, Clause 22, a ruler was defined to mean the prince, chief, or other person by whom covenant and agreements were entered into, and who for the time being was recognized by the president as the ruler, and included any person who for the time being was recognized by the president as the successor of such ruler. Naturally, most congressmen were opposed to the idea of payment of privy purses to the princely states, but Sardar Patel made a stirring speech in Constituent Assembly on October 12, 1949, saying that whatever the amount it is small if it means keeping India integrated, and thus this step was necessary to keep the sovereignty of India strong. He told them that the cash assets received by the rulers of Madhya Bharat alone were sufficient to cover the payment of privy purses to all princes. Therefore, to deny them their due would be a complete breach of faith. Following this, the congressmen agreed, and the provision of privy purses was introduced. The problem started in 1967 with the formation of Swatantra Party by C. Rajagopalachari. Many rulers and many princes started joining Swatantra Party and left Congress, naturally infuriating Indira Gandhi. Trying to get revenge on on September 5, 1970, Indira Gandhi brought a law in Parliament to abolish the Privy Purses. It was passed in the Lok Sabha with majority, but was defeated in Rajya Sabha by one vote. A few hours later, President V.V. Giri, purporting to exercise power under Clause 22 of Article 366 of Constitution, he signed an instrument withdrawing recognition of all rulers, thus reneging on the constitutional promise that honored the commitment of Sardar Patel to all princes. This whole process was done in such unwanted hush that it created suspicions. Following this, this issue was moved to court by all the princely states under Article 32 of the Constitution by the petitioner, challenging the order of President of derecognizing them as unconstitutional, ultra vires and void. The petitioners contended that President had no power to withdraw recognition of a ruler once recognized. Also, that assuming the President had such power, to exercise the power was coupled with his duty to recognize a successor. Also, that the order of the President derecognizing all the rulers en masse amounted to arbitrary exercise of power for a collateral purpose. The petitioner also challenged that the order violated the constitutional mandates in Article 291 and Article 362. They also argued that Article 291 created an obligation on Indian Union to pay Privy Purse, and Privy Purse was a property of them. Also, the order being one without authority of law infringed the guarantee of fundamental rights under Article 19 subclause 1F, 21 and 31 of Constitution. These were the arguments provided by the petitioners, including all the princely states. Answering to this, the contention of government was that the Article 291 did not impose any kind of obligation on the Union of India to pay the Privy Purses. Article 291 and 362 of the Constitution did not invest the petitioner and the other rulers with any such enforceable rights. Also, the reason which was given to take Privy Purses back by the government was that they were looking forward to create a socialist and welfarist state, and the government of India can't afford every year to pay so much amount from the government treasury to these princely states. This would clearly become a hurdle in their dream to make India a socialist economy. Now, the question of law before court was that the first question lied upon the validity of the action of the President, and the second was that whether the government of India acted in exercise of its sovereignty, and whether this under Article 363 puts a bar on the court from interfering to provide relief of any kind. The court held that there can be no paramountcy against a citizen of the India, and the rulers today are not potentates as they were. They are citizens of India like other citizens, albeit with some privileges and privy purses which other citizens do not get. That is an accident of history, and with the concurrency of the Indian people in their constituent assembly. The power has been exercised against them must therefore be justified by the Constitution and laws, and not by invoking a nebulous doctrine of paramountcy. talking about the supremacy of the court, the Honorable Court finally said that we further hold that the president is not invested with any political power transcending the constitution, which he may exercise to the prejudice of the citizens. The power of the president arises from and is defined by the constitution. Also, commenting on the act of the president, the court said that the president had acted ultra vires to the constitution when, in the instant case, the parliament refused to amend the constitution. The president's power did not extend that far by executive action. Thus, the attempt to remove Article 291, 362 and 366 Clause 22 from the Constitution without a hearing to the rulers was in breach of the accepted principles of natural justice. Indira Gandhi took this humiliation took this judgment as humiliation, and just 9 days after the verdict, she called upon the president to call fresh elections. Riding on the Garibi Hatao motto and socialist agenda, she came back to power in Lok Sabha, and this time on July 31st, 1971, under 26th Amendment, she omitted Article 291 and 362 from the Constitution and inserted a new Article 363A, in which all privy purses were seized and abolished. The shocking justification given to abolish privy purses was that it was incompatible with the egalitarian social order, and there was not a single mention of the enormous efforts required to persuade the princes to be a part of the integrated India, thus putting the case to the end. Giving my opinion, I think that privy purses shouldn't have been abolished, because according to me, and also quoting Sardar Vallabhbhai Patel, that would have been a clear breach of faith to what was agreed. At the time of the independence, the princely states were not at all liable to join India, and if they have joined India, they did so on basis of certain promises which were made to them, and those promises, I believe, must be respected by the coming future governments of the country too. Thank you. Good afternoon, everyone. My second case in the sequence is S.R. Bommai versus Union of India. So, again, starting with the background, S.R. Bommai was the Chief Minister of Janata Dal government in Karnataka between August 13, 1988 and April 21, 1989. So, while he was in the government in Karnataka, but during his tenure, several MLAs defected and joined other parties, leaving Janata Dal to be a minority government. Eventually, his government was dismissed on April 21, 1989 under Article 356, and president's rule was imposed in Karnataka. Back then, the practice of president's rule was a common practice to keep opposition parties at bay. So the grounds of his dismissal were that the government had lost majority following large-scale defections engineered by several party leaders of the day. S.R. Bommai then gathered all the MLAs back and asked the then governor P. Venkata Subbiah to prove his majority back. The governor, despite receiving 19 letters from Bommai, refused to give him the opportunity and said that after some time fresh elections would be conducted so that a new government can be formed. Following this, Bomai went to the Karnataka High Court to challenge the government's decision, but the High Court upheld the governor's decision and dismissed Bomai's writ petition. Then S.R. Bomai went to the Supreme Court of India. At that time, coalition governments were forming in the country, and Article 356 was being misused very frequently by Congress government. One instance was that after Babri Masjid demolition in 1992, under the P.V. Narasimha Rao's government dismissed governments of 3 different states on no valid grounds. These were the BJP-led governments in the states of Rajasthan, Madhya Pradesh, and Himachal Pradesh. So yeah, that was the instance. And when S.R. Bomai took his case to the Supreme Court, it almost took 5 years to see the judgment. The issues raised in front of the court were that whether the president's rule inflicted in the 6 states at that time was constitutionally valid or not. Secondly, whether the president has unchained rules to proclaim Article 356 one of the Indian Constitution, and if yes, what is the scope of judicial review in this regard. Also he asked one issue raised in front of the government was that what's the meaning of the phrase that a situation has arisen in which the government of the state cannot be carried on under the provisions of this constitution used in Article 356(1). So these were the challenges in front of the court. So the arguments made by the petitioner was that firstly, S.R. Bomai was not allowed to prove his majority. Second, that the command of president's rule in the states was malified based on no compensation and was completely a political act. Just a little disturbance in an area does not provide any reason to force president's rules. Also, thirdly, it is the duty of the union government to duly present in front of the court all the information they have received upon which the essential satisfaction was taken and the president's rule has been imposed, which clearly they haven't. So under Article 74 Clause 2, Union of India cannot be discharged of this obligation. So these were the arguments made by the petitioner, and answering to those, the arguments made by the respondent, that is the Union of India, were that there is a difference in the nature and extent of the power of legal analysis in administrative and constitutional law. The definition of the current dispute is that whether or not Constitution has given preconditions for the exercise of power by the constitutional authorities, the courts cannot review whether the pre-existing conditions have been met. Also, secondly, if the powers are committed to a constitutional authority for performing a specific purpose, and if the relevant authority under the cover of achieving the said purpose uses the powers to accomplish an impermissible target, such use of power cannot be questioned. Also, on behalf of Indian Union, it was argued that only in the opinion of cabinet provided under Article 74 Clause 1 of Indian Constitution, a proclamation under Article 356 may be declared by the President, and an inquiry into whether or not any advice given to ministers by the President is just prohibited. Also, by subsection 2 of this article, the legal analysis of the reasons that led to the publication of the declaration is also prohibited. So these were the arguments made by both the sides in front of the Supreme Court. the judgment finally was that the court held the court held that the exercise of power by the president under Article 356(1) to issue proclamation is subject to judicial review, at least to the extent of examining whether the conditions precedent to the issue of the proclamation have been satisfied or not. This examination will necessarily involve the scrutiny as to whether there existed material for the satisfaction of the president, that a situation had arisen in which the government of the state could not be carried on in accordance with the provisions of the constitution. Also, the verdict also concluded that the power of the president to dismiss state government is not absolute, and the president can only exercise the power after his proclamation is approved by both the houses of parliament. The formula of suspended animation was used, which said that you can only suspend the government for the time being, and meanwhile the governor of the state has to take all such necessary measures to restore the government back in his state. While the government is being suspended under the suspended animation thing, the governor must allow other parties a chance to form the government, and only if it fails, then also it must be dissolved and elections reconducted. Also, the court said that it has the power to overrule the proclamation issued by the president, whether it is approved by the parliament or not, thus bringing the proclamation under the purview of judicial review. The court also supported the findings of Sarkaria Commission by endorsing the guidelines given in its report, including the issuance of warning to the errant state that it is not carrying on the government of the state in accordance with the provisions of the constitution, along with procedural recommendations. Also, the court also reiterated that the secularism is one of the basic features of the constitution. Any state government which pursues unsecular policies or unsecular course of action acts contrary to the constitutional mandate and renders itself amenable to action under Article 356. So this was the judgment basically given by the court in this regard. Finally, the conclusion of the case as such is that the case dealt with assessing the lawful mechanism and searching the whole area of constitutional imperatives on central state relations and the contentious role of state governors upon calling the president's rule. The fact that under the system of our constitution, great power is discussed upon the center vis-a-vis the states does not mean in any sense that the states are little appendices of the center. The states are the greatest strength within the fields which are assigned to them. The center thus cannot and must not tamper with their powers. Thank you. The third case in the sequence is Minerva Mills versus the Union of India. So basically, Minerva Mills was a textile limited company of Bangalore, Karnataka, dealing primarily in textiles, and seeing its working, the government had its doubts from the beginning onwards that the company was not working efficiently, and thus it would be better if the company was instead nationalized. So the government on August 20, 1970 set up a committee for investigation into the matter under section 15 of Industries Development Act 1951, and once the committee was formed, the committee studied the case and submitted its report on January 1971 to the government. Upon receiving the report, the government passed an order on in October 1971, authorizing the National Textile Corporation Limited to take over the management of Minerva Mills, as it was working in the interest detrimental to public. So it insisted the National Textile Corporation Limited to take over the company under Section 18A of 1951 Act. So thus the company was nationalized under the provisions of Sikh Textiles Undertakings. Under the provision of Sikh Textiles Undertaking Nationalization Act 1974. And once this decision was made, this takeover was challenged in High Court, but was consequently dismissed by the High Court. Later, it was challenged in the Supreme Court by filing a writ petition under Article 32 of Indian Constitution. So the primary issue in front of the court was whether the Section 4 and Section 55 of 42nd Constitutional Amendment destroy the basic structure of Indian Constitution or not. Secondly, also the can DPSP coming under the Part 4 of Constitution have primacy over fundamental rights. This was the second issue which the court was facing. So at that time, before this Minerva Mills case, the parliament already suffered massive defeat in the Indira Nehru Gandhi versus Sri Raj Narayan case, and thus in order to make its power once again supreme, the government passed 42nd Amendment to bar any challenge on constitutional amendments in courts of law. So through 39th Amendment Act 1975, Parliament inserted Nationalization Act 1974 into 9th schedule, which basically means that any challenge on the said act was outside the purview of judicial review. So from the side of the Minerva Mills Union, the petitioner Nani Palkhiwala challenged the constitutionality of Section 5 Clause B, 19 Clause 3, 21 Second Schedule, 25 and 27 of the Sikh Textile Undertakings Nationalization Act 1974 in front of the Supreme Court. He also challenged the order of central government dated 19 October 1971. He also challenged the Section 4 and 55 of 42nd Amendment 1976, and he also raised issue over the primacy given to directive principles of state policy over fundamental rights. So basically these were the issues of the petitioner, and the arguments made by petitioner in this regard were that amendment powers of Parliament are limited under Article 368, and this amendment, the amendment in this subject, would make Parliament the master of the Constitution, which shouldn't be the case. Also, he said that the court's decision in Keshavanand Bharti case already mentioned that Parliament has no authority to disturb the basic features of Constitution. He also said that it was an obligation on the state to pass laws on directive principles of state policy, but it should be done through permissible means and shouldn't overrule the fundamental rights. Due to Section 55th of 42nd Amendment 1976, no court would have the power to review constitutional amendment passed by Parliament. This would basically and clearly damage the balance between Parliament and judiciary. He also raised the issue that because of this judgment, a disbalance has been created between the fundamental rights and the DPSP. He also said that in such a sequence, almost every law enacted by the government would in one or the other way be associated with directive principles only. And to basically give immunity to directive principles over fundamental rights would wipe out Article 14 and Article 19 of the Indian Constitution completely. So in regard to this, the arguments again made through the respondents' sides were the advocates through the respondent sides were L.N. Sinha, Attorney General L.N. Sinha, and the additional solicitor K.K. Venugopal. The arguments made by respondents were that the Article 31C of Indian Constitution reinforced the basic structure doctrine, and directive principles just provided goals in the absence of fundamental rights. They also argued that any harm that is caused to fundamental rights won't amount to violation of basic structure doctrine. They said that there is the issue that the achievements of goals framed under DPSP should be supreme, and thus no restrictions on Parliament's amending power should be entertained in this regard. They said that the government, through the nationalization process, was just assisting the company to raise loans. They also emphasized, the respondents also emphasized on Article 38 and argued that any law in compliance with Article 38 just couldn't abrogate the fundamental rights or destroy the basic structure, as the structure is founded on justice, social, political and economic principles, and Article 38 enumerates upon the same. So these were the arguments made from both the sides, and the judgment in regard to this made by the court was given on 31st July 1980, and the decision was pronounced by a 5-judge bench of Supreme Court with the majority of 4-1. So the majority opinion was presented by Justice Y.V. Chandrachud on behalf of Justice A.C. Gupta, N.L. Untwalia and P.S. Kailasan. So their decision on Article 368 was that Parliament has the amending power but should be within its basic framework. They said the theory of unlimited power so they said that the theory of unlimited power to amend constitution would alienate democracy and create a totalitarian state. They deemed clause 5 as unconstitutional because it hampers the basic structure of constitution. They also struck down the clauses which were limiting the court's power of judicial review on the constitutional amendments. On Article 31C, the majority was of the opinion that if Part 4 subverts Part 3 of Constitution, it would destroy the basic structure, and elementary freedoms which were given under the Article 14 and 19 must be preserved in any case. They also said that the Article 31C has removed 2 sides of the golden triangles. The golden triangles being Article 14, 19 and 21, and Article 31C has just removed Article 14 and 19. If this happens, this will cause serious harm to the people of this country. They said that the Part 4, that is the DPSP, needs to be achieved without the abrogation of Part 2 of the Constitution. And also finally the minority opinion was given by Justice Bhagwati, and on his opinion on Article 368 was basically the same as of the majority opinion. He was in favor of majority in striking down section 55 of 42nd Amendment 1976. He opined that the basic features are an integral part of the Constitution. He also deemed Clause 4 as unconstitutional because it breached 2 basic features of Constitution. First, the amending powers of Parliament, and second, it did put a restriction on the judicial review of the courts. He deemed Clause 5 as unconstitutional and void because it had an effect of transforming the constitution into an uncontrolled one. But on Article 31C, Justice Bhagwati was of the different opinion from the majority, in the sense that he said that Article 31C didn't damage the basic structure but instead strengthened it. And he was also of the opinion that non-compliance of directive principles of state policy would be unconstitutional and a breach of faith with the people. Thus, no law directly giving effect to the directive principles can be inconsistent with the vegetarian principle. So these were the majority and minority opinions in the case, and the final decision was that the section 4 and section 55 of 42nd amendment were deemed unconstitutional, and the other things, the writ petitions, the writ petition from the petitioner side challenging the validity of section 5 subclause B, 19 subclause 3, 21, 25 and 27 were all dismissed by the court. Thank you.